Good afternoon, everybody. Good evening, everybody. Thank you for coming. My name's Tom Keating. I'm director here at RUSI of the Centre for Financial Crime and Security Studies. And we're delighted to welcome you here to RUSI this afternoon for our discussion with David Green, QC, Director of the Serious Fraud Office. David said to me when I saw him at the Cambridge Symposium, I've never spoken at RUSI. And I said, right, you will speak at RUSI before you step down. And true to his word, he has accepted our invitation. So, David, thank you very much indeed. David has an illustrious career, which I won't rattle off. But obviously, for the last 6 years, he's been at the helm of the SFO, and that leadership will come to an end this year. I think we can probably all agree it's been an important 6 years for the SFO. It's certainly, from my perspective, been an eventful 6 years, and obviously has involved cases, included cases involving a range of household names and much more. And we're delighted that he's agreed to come and reflect on his time at the SFO with us this afternoon. We are equally delighted to be joined by Alison Levitt, QC, who's agreed to chair the discussion this afternoon. I know these two have known each other for a long time, so I'm hoping we can just sit back and they can kind of catch up and forget that we are here. But Alison, as well as now being a partner and head of the business crime group at Mishcon de Rey, has been the principal legal advisor to the director of public prosecutions, and perhaps most importantly is a very valued, long-standing member of the advisory, founding member of the advisory board of our program at RUSI, and also has become a trustee here at RUSI. So we're grateful to her for all of that as well. So the intended format is that we'll have a discussion between Alison and David for the next sort of 20 to 25 minutes. There won't be a formal speech, and then we welcome as many questions as you all want to pose from the audience. With that in mind, my usual request for you not to make statements, but to ask questions. Please don't make lengthy interventions, and we'll aim to finish around 6 o'clock-ish. The event is entirely on the record, so please bear that in mind, at the request of your office. So please bear that in mind when asking your questions. So with that, Alison, I'll hand over to you, if I may.
Thank you very much, Tom. Okay, David, so let's start with the easy stuff. For the benefit of any non-lawyers in the room, can you just tell us a little bit about why the SFO is different to the other agencies? What is the Roskill model, and what's the relationship like between the Serious Fraud Office and, for example, the National Crime Agency or the police or the CPS?
1985, there was a commission on fraud trials set up under Lord Roskill, who was a judge in the then House of Lords. And it was set up because there was concern that the traditional system of police investigating, taking a file to prosecutors making decisions and then putting it through the jury system, there was concern as to whether or not that was really up to the task of the kind of serious and complex fraud that was coming down the line in the mid-80s. Lord Roskill sat with his commission and came up, unsurprisingly, with the Roskill model, which is essentially a single organisation which both investigates and prosecutes. But it's more than that. It's under one roof. You have every skill necessary, including from the bar, to conduct an investigation and a prosecution. So we are a kind of self-supporting organisation that uses the independent bar to conduct our cases in court. So that makes us almost unique. I think there are one or two smaller agencies that have that model, but almost unique. Our remit is England, Wales and Northern Ireland, not Scotland. The Scots do their own thing, and that's what makes us different.
And I think you have the power, don't you, to decide which cases you're going to take on. So could you just help us as to what your criteria are, and are financial constraints any part of that?
I, by statute, have power to investigate anything which I consider on reasonable grounds involves or may involve serious or complex fraud or bribery. And once I have opened an investigation, we are then able to use our Section 2 powers, which are fairly draconian and deliberately so, powers to compel answers from potential witnesses and also powers to compel production of documents. There is one exception now in the case of bribery investigations. We can actually use Section 2 before I have formally opened an investigation. So that's how we take things on. Our case criteria, every director, I think, sort of rejigs it slightly. It's incredibly difficult to be precise. You cannot use a monetary framework, really, that would be meaningless. So what I said, I took it back to what I thought was the original purpose of the SFO, namely that we investigate cases which undermine UK commercial or financial PLC in general, or the City of London in particular. And if you look down our case list, Barclays Bank, LIBOR, Rolls-Royce, Tesco, so forth, you'll see they fit that profile. And also, we do large-scale pension frauds and new species of fraud. And you'll know that in the past few years, since pension liberation came along, there's been an enormous amount of well, not an enormous amount, but certainly a new type of fraud involving cold calling pensioners to get them to cash in their pensions and invest increasingly in green energy schemes in the developing world. Does finance play a part?
Well, have you ever not taken a case because it would cost too much?
Never once, no. We have a special arrangement, which is the envy of many Whitehall departments, which we call Blockbuster, which means that if any case costs more than around 5% of our annual budget, so effectively that's about 1.5 million in any single year, then we make a business case to the Treasury, and they have in the past always provided the money for that additional investigation. We couldn't have taken on, for instance, LIBOR and commit at its height nearly 90 people to its investigation without Blockbuster funding. Equally with Rolls-Royce, the scale of that case, 30 million documents, we couldn't have conducted that efficiently and reasonably quickly without committing, I think, up to 60 people, and we couldn't have done that without Blockbuster funding.
So I said we'd start with the easy stuff. Let's try another easy question, David. When you first arrived at the SFO in 2012, in what sort of state did you find it, and what changes did you think might need to be made?
Well, of course, the SFO now overlooks Trafalgar Square, or my office does, and that's a very privileged position. In those days, it was on Elm Street up in King's Cross, and had earned the nickname the Nightmare on Elm Street. It was a strange place. The building itself looked really like a kind of insurance company in Hornchurch. I hope no one comes from Hornchurch, but that's what it looked like. Rather sort of unimposing 9-storey building, which really wasn't people-friendly at all, because the sort of public areas were very small and nobody really met anyone. It just wasn't a people-friendly building, so it was good that we moved. How was it? Well, my predecessor had, I think, with some courage, tried to adopt a kind of American approach to things as he saw things. He was inclined to speak directly to companies, to call them in and reach kind of civil settlements. That's what he wanted to do. He saw that as the way forward, as opposed to prosecution. I think he'd agree with that change of emphasis. The problem was, of course, there was no statutory framework to do that. And unlike now, obviously, I've got deferred prosecution agreements by statute, which have been an extremely useful and effective tool. He didn't have that. So the sort of nadir of what happened to the SFO in those days was the case of Innerspec, where effectively an agreement appears to have been reached as to sentence between prosecution and defence in the event of a plea of guilty, which was then basically put in front of the court, and the court was then effectively the Deputy Lord Chief Justice, who wasn't best pleased, and his judgment is worth reading in that regard.
So How do you think SFO cases differ from those handled by other agencies? And for example, I'm sure you won't mind me saying that to the general public, it often seems like SFO cases take an extremely long time. How would you categorise the sorts of things that you do and what makes them different?
Well, our cases are always serious and complex. That's by definition they are. They will involve vast amounts of data. I mentioned Rolls-Royce, I think 30 million documents. These days they're all usually digital documents. All of these have to be uploaded onto our mainframe computer and looked at, inspected individually for evidential worth and relevance. What else? Obviously evidence obtained from abroad, but then that's so for many cases, maybe very difficult jurisdictions where you're trying to get evidence from. What else? We may need fairly unusual experts to get them, very rarefied expertise to bring them in. So it's complex, it's very detailed, and the case theory, because you're investigating and prosecuting, the danger against which you have to guard fairly constantly is the evolution of what might turn out to be a false case theory, or a false theory of what was actually happening in terms of what you're investigating. So the cure for that is always to have layers of challenge. So we have within the case teams, each case team, investigation team, is headed by a case controller and will include usually an accountant, a few investigators, counsel that we've hired for the case. It will include computer experts, any other necessary experts, and they work through it. So, yeah, that's how it works.
So, issues about difficulties with disclosure in criminal cases have been much in the news recently. Bearing in mind how document-heavy some of your cases are, how have you found ways of dealing with disclosure, and are these things that could be adapted for use by the other agencies?
Well, you're right, we deal with huge amounts of information. I think there was an interesting development in the Rolls-Royce investigation, because there Rolls-Royce cooperated fully with us. And incidentally, you raised the point of why some SFO investigations take a long time. It's volume of data and whether or not the company itself chooses to cooperate with us. If you are
Yes, I've given you the special comedy
yes, I know.
leaking pen.
Yeah, thanks a lot. Some companies choose to cooperate with us, others don't. Now, you would not expect us to give up and walk away, and believe me, some companies do. They think, well, we'll just ignore the SFO, and they'll give up and walk away and get bored. Well, obviously, we don't do that. It kind of goads us something rotten, and we will keep on till we get a result, one way or another. So that's how. That's why some investigations take much longer than others. In terms of disclosure in the Rolls-Royce case, they fully cooperated, and a measure of their cooperation was this, that they gave us 30 million documents, and they said, look, this contains without question the stuff you will want to see, involving corrupt payments in up to 7 jurisdictions, touching 3 decades in 3 or 4 streams of their business. But it also contains legally privileged material. And we trust you to weed that out, because obviously we're not entitled to see that, nor would we want to. So what we did with their agreement is to use artificial intelligence to build an algorithm. Now, I don't really understand this, but I can tell you what I was told. You build an algorithm, and it is seeded, basically, with, say, 7,000 documents in terms of keywords that will pop up and identify legally privileged material. And as it goes along, it actually learns and it increases its sensitivity and intelligence. And normally we would have had 30 young barristers in for, I don't know, a year to go through, or more, to go through all that documentation. In fact, the interesting thing, we found that AI it completed everything in a third of the time, On a basis of dip sample testing, it was more efficient and more reliable than human intervention. And of course, the robot, the artificial intelligence, didn't have to go to pret-a-manger, it didn't need coffee breaks, so that worked really well. Now, why I raise that in that rather cumbersome way is that surely, with the consent of the courts, eventually, when the technology is sufficiently familiar and trusted, then that can be applied to the disclosure regime. I think very effectively and reliably, and the defence can have input into what keywords are to be used in the search. I see that certainly as the way forward once people are comfortable with the technology. It does mean, of course, that the defence, and just now and again I've noticed over 30 years, the defence are a little unwilling to cooperate in the disclosure process. They will need to get on board.
So I want to ask you a bit about deferred prosecution agreements. I think I'm right that there have been 4 concluded DPAs, basically since they started. To some people that may not seem like very many. Are they likely to play a significant role in the future, do you think? Very
much so. It's because what they amount to is a very important part of what I call the offer. When I first came into the job, I addressed and still do address numerous collections of city law, with respect to yourself, Alison. And always the moan was, we won't self-report to the SFO because my clients need certainty and we haven't got any certainty. Why, I've often wondered, a company is any more entitled to certainty than a burglar, I've no idea. But companies feel they need certainty, fair enough. Now they do have certainty. They know that if they fully cooperate with us, and I mean fully cooperate, then odds on they are heading for a deferred prosecution agreement. If they do not, they will be prosecuted. And what can't happen, and I've heard 1 or 2 people suggest this, is a kind of Damascene conversion, to mess the SFO around for 3 years, say, and then suddenly sack the solicitors, get a new lot on board, sack the bad guys in the boardroom and say, OK, we want to cooperate now. No DPA for that.
But of course, in 1 out of the 4 DPAs you did, the company Rolls-Royce didn't self-report.
Well, if I know you will have read the judgment with huge care, and particularly the care with which Sir Brian Leveson applied to it. And he said this, that when he first read it, he thought, well, if this isn't to be prosecuted, what is? But then he learnt of what he called, and various descriptions were applied to it, that he settled on extraordinary degree of cooperation, and I've illustrated that earlier in terms of the robot and giving over material to us. He said their cooperation was such that it put them rightly in the position as if the company had self-reported. What actually had happened is that back in 2012, soon after I came in, our intelligence section had noted things on the internet concerning allegations of bribery in China, Indonesia, and I think 1 other jurisdiction. And we thought it polite to call Rolls-Royce in and say, tell us about it. And instead of saying, we're looking at it, they said, well, actually, and this characterized their behavior from that point on. They said, this is just the tip of the iceberg. We know we have far greater problems in other jurisdictions. And of course, we then launched a criminal investigation and indeed found the extent of their problems, which was very considerable. And you had in Warren East an impressive chief executive officer who'd come in and was determined to draw a line under what had happened in the past. So new board, new top management, they were determined to do that. And I think it was quite right that they were rewarded with a DPA.
You'll know, of course, that some people regard DPAs as, in effect, a get-out-of-jail-free card for big companies. And the suggestion is that why should they, in effect, be allowed to buy their way out of prosecution? Is there anything you want to say about that?
Well, get out of jail free rather hits the nail on the head, doesn't it? Because, of course, you can't jail a company, so you can only fine it. Now, what are you going to do with a company if it genuinely wants to change, gets rid of the bad guys, really lives compliance and understands its importance, puts in place training, believes in it, fully accounts in a transparent way to a court for its criminal conduct and honestly wants to draw a line under what has happened in the past. Is it the right thing to do to prosecute them? I think not. I think you give such companies encouragement to come forward, and the encouragement is, with the DPA, that they avoid a criminal conviction and the possible consequences of a criminal conviction, which may include disqualification from being able to compete for public contracts here in the US and in other jurisdictions and in Europe.
You probably agree, David, that the success or failure of the SFO, like most organisations, will hang or fall on the quality of its staff.
Yeah.
It's no secret that pay levels are considerably lower in the serious fraud officers in most public sector jobs than they are in the private sector. So how do you go about recruiting and retaining significant legal talent?
One of the things I'm most proud of is I think it is recognised by our staff, past and present now, that the SFO has become a very useful addition to an aspiring lawyer, an aspiring investigator, an accountant, to have maybe 2-3 years at the SFO on their CVs. Now that can only be a good thing, because I cannot possibly, as you rightly say, compete with private sector pay, nor would I wish to. But I think we're going to move towards increasingly the American model of the revolving door, where people go out of into government, out of government into private sector, and then back, and sometimes repeat that many times, several times.
And of course, both of us are examples of that.
So I think now, yes, we can attract staff because of the quality of work we do, because of the experience we offer. Would one be able to keep them? Well, yes, some people have a real public service commitment, as you know, and would stay, and money does not drive them. Otherwise, some people would, as I say, come to us for a while, then go off into the city, and there's been a number of well-known examples of senior managers from the SFO who's done precisely that. And good luck to them.
Can I just come back to the SFO?
Both of them told me they'd give me 4 years, and they gave me 4 years almost to the day.
Can we return just to the funding model for a moment? So you have your core funding and then you have Blockbuster funding. And I want to ask 2 questions about that. The first is, isn't Blockbuster funding rather wasteful and inefficient? Because aren't you having to take on a whole lot of lawyers for a particular task who then aren't, as it were, permanent members of staff?
Well, when I came in, I think our staff level was 280, some maybe 270. It's now a total of about 500. Which I think is the proper staffing level. Of those, that includes about somewhere around 150 to 180 people on short-term contracts, which may be up to 2 years, rather than permanent members of staff. Is it wasteful? Well, the problem is you can't keep, can you, a standing army sitting around waiting for the right case to come in. We do not know what is around the corner. We must have the ability to flex, to take on that kind of work, and we've done so, and the Blockbuster model allows us to do just that. It's not perfect, but it's the least imperfect model of funding.
And the second question arising out of that is, obviously, when you want Blockbuster funding, you go to the Treasury and you say, in effect, you make a business case.
Cap in hand to the Treasury, I think is the usual phrase.
And you will know, of course, where this is going. Does that not allow for the possibility of political interference, that if it's an unpopular investigation or prosecution, that the Treasury will cut the funding and you won't be able to investigate?
Well, what do you think I'd say in that event?
I don't know, you tell. It's nice people here who want to hear it from you.
I have put it this way, I've never had the slightest difficulty in getting money from the Treasury. It's quite right, they should have a proper business case to say, to explain that we are investigating something serious and the scale of it. No more real detail than that. And that allows us to do it. I think it's, as I say, it's the least imperfect system, I think.
And on the subject...
And if I was told, no, we can't have money, then I think, obviously, that matter would, well, not through me, but it would inevitably become public knowledge because it would be known. So, that in itself, I suppose, provides a safeguard.
And on the subject of political pressure, there's been considerable uncertainty over the SFO's future over the last couple of years, and indeed at one point you were told that you were not going to be here for much longer. In December, it was confirmed that the SFO is no longer under threat, but we were told that the National Crime Agency would have a power directly to task the SFO, and I want to ask you a bit about what that actually means, because it seems a rather puzzling concept. Given that the National Crime Agency is itself an investigation agency, why should it have a power to direct the SFO to investigate something? Or is it in fact the power to direct the SFO to prosecute, which would throw up a number of significant issues about prosecutorial independence, wouldn't it?
Well, the power to direct us on prosecutions does not and will not exist. What they have, and it's not yet settled exactly how an amendment would be brought in, what they would do is have power to refer a case to us. Of course, it depends how it's worded, because, as I said earlier, I have to decide on reasonable grounds whether or not conduct may include serious or complex fraud before I can open an investigation. Now, if something was referred to me and I didn't think it met that test, I couldn't take it on by statute as things stand now. But in reality, you know, a couple of things pertain here. The first is that the SFO, the NCA, have had a power of direction over police chiefs since when? 2013. It has been used once, and it was used at the request of the police, not at the instigation of the NCA, because they wanted such a direction. I cannot imagine that the sensible route, which, believe it or not, operates most of the time, which is simply a phone call to me or to one of my senior team from any agency, frankly, could you look at this? Well, of course we would. But insofar, as I told the Justice Committee on the 13th of December, insofar as this proposal, this proposed amendment, is designed to achieve greater cooperation and coordination amongst the agencies on the economic crime waterfront, who could possibly object to it? I certainly don't.
Moving to a slightly different topic, one of the most recent cases involving the SFO has been when you have challenged the defence's view that they're entitled to keep the product of an internal investigation to themselves on the grounds of legal professional privilege. This is, of course, going to the Court of Appeal, as we know. But it's right, isn't it, that the Department of Justice in America takes a rather different view. Isn't there then a risk that internal investigations will simply be done by American law firms rather than English law firms, which isn't great for UK PLC, but also that there is a risk that companies will, put it this way, what you want is for everybody to stop doing the corrupt things that you believe they're doing. Isn't there a risk that if they're going to have to show you everything they've got, they're going to see that big stone sitting over there and they're going to think, maybe we'll just leave it where it is rather than picking it up and seeing what's underneath it?
Well, let's start at the beginning. The SFO thoroughly respects and has no problem at all with privilege claims. We have problems, once or twice, that we have identified, where we don't particularly trust the first assertion of privilege in particular cases. That's happened in 2 cases. Where it has happened, we have asked the other side to explain on what basis they claim privilege, and where we do not accept that explanation, we will litigate and have litigated. There is no campaign against privilege. Secondly, what we believe we are perfectly entitled to see and what we're interested in, for obvious reasons, are the unvarnished first factual accounts taken from witnesses. Why do we need those? 1, to assess credibility of the witness. 2, to help us in our duties of disclosure as and when they kick in. I think the ENRC judgment as well, to which you referred, the third point, if one reads, I think it's between paragraphs 45 and 54, you will see that the judge, she is very careful to say, in essence, I'm not finding that this material is privileged because they haven't put any evidence before me that it is privileged. And it's very fact-specific, I think. And in terms of the Court of Appeal, considering ENRC, bring it on.
So you're leaving in April. You've done nearly 6 years.
6 years to the day.
6 years to the day.
Friday the 20th of April, shortly after lunch.
So I have a couple of short questions then. What was your proudest moment?
Oh, no, I don't have proud moments.
Don't you?
No, no, I don't.
All right. Then what's your fondest memory?
Oh, dear.
It's not liking these questions, is it? All right. We'll try another one. Any regrets?
Regrets, I've had a few, but then too few to mention, really.
And any advice to your successor?
No, absolutely not. Absolutely not. Except maybe I will hopefully get to speak to him or her and say, look, do you think it might be a good idea to keep on the same course that we have upon which we are currently embarked, so that it gives some consistency to city law and so forth, who I think now understand us. They understand the offer, they understand what you need to do for a DPA, they understand what you need to do to get prosecuted. So,
Right. So are there any questions from the floor? I think there are some roving microphones. So, gentleman there.
Thank you very much.
Could you say who you are and where you're from?
Ewan Grant, a RUSI member and former law enforcement, customs and excise, particularly working in the ex-Soviet countries, so seen the brass plates and all that follows from that, and how traditional criminal prosecution is more or less a waste of time. You need to look at your approach. Never come across anybody who thought merging SFO and NCA was a good idea. My question is, you've mentioned cooperation with the US and basically much of the model based on US practice, not all of the model. What about cooperation with the continental European EU countries and the likes of Switzerland, Andorra, Liechtenstein? Because we've seen in a number of cases, particularly in the defense industry, there's a lot of issues in these countries, and perhaps certain people are looking rather rose-tinted spectacles at these countries, and that Britain is more honest about what we need to do to clean things up. So what cooperation qualitatively and quantitatively with those various countries? Thank you.
Cooperation generally, I can illustrate it in this way. Outside of Europe, in the Rolls-Royce DPA, we were able to coordinate and make land at precisely the same time settlements with us, with the Department of Justice, and with Brazil. That was done by a lot of talking and a lot of visits. But the point is, it was coordinated. Secondly, in another case, I won't say which, we were able to coordinate globally simultaneous searches in 4 different jurisdictions. Now that takes some doing, and you have to get to know the agencies operating abroad. Sometimes they're police forces. You have to understand what the impediments might be, but it's absolutely crucial that the people go in through the door in different jurisdictions at precisely the same time, and that we have been able to do. In Europe, we have a high level of cooperation, both incoming letters of request and investigation or judicial investigation orders, EU investigation orders now. We have a high level of cooperation. You mentioned specifically, say, Switzerland. There we've had a good level of cooperation. When there's been difficulties, I myself has been to Switzerland and discussed matters with senior officials over there, so have other SFO personnel, but I wouldn't want to represent that the Swiss have been in any way a problem. It's just an example of how we deal with things in a practical and, I hope, sensible way.
Gentleman at the back there.
David Page, RUSI member. I'm not a lawyer. I
Good for
regard
you.
myself as somebody who actually I didn't expect to be in the room, but there we go. The UK, I think it's interesting you talk about cooperation, because the example I can think of, which is now a few years ago, is over the Cheshire Building Society, which collapsed almost after being hit by some professional fraudsters.
I have to say I'm not an expert on the case.
No, but I've used it as an example. is where there was almost no cooperation from the banks that had been hit by the fraudsters.
Yes.
So in actual fact, I can't remember the exact figure, but I think it was 5% of the frauds that they had committed were actually reported to the police. And that makes me wonder whether cooperation is very much a one-way street.
You're talking about cooperation with banks as victims, if you like.
Yes.
Yeah. Well, I think you're quite right. That is something that I think all prosecution agencies in this country have seen, and police have seen as well. And I think the answer is fairly obvious, that banks don't like to admit that they've been taken for a ride. And there have been cases, certainly, when their cooperation has been less than perhaps it should have been.
I'm going to stand up so I can see. Oh, Martin. There's a...
Sorry, Martin Bentham from the Evening Standard. Unexplained wealth orders become available tomorrow. Lots of people are very excited about these. Transparency International, for example.
I know you are, Martin, as well.
Exactly, yes. Suggests there are about £4 billion worth of property
Yes.
in the country that could be targeted by this.
Yeah.
Are they all getting overexcited? Am I getting overexcited? How useful is this going to be? And how many unexplained wealth orders do you anticipate the SFO might have been able to apply for over the next year?
Do you remember when the Bribery Act came in? All I ever got asked at occasions when I was asked to speak or answer questions was, when are you going to have a prosecution under Section 7 of the Bribery Act? I said, in the fullness of time, when the time is right, all those. And then eventually there were such prosecutions, and they also formed the basis of deferred prosecution agreements. These things take time. Don't imagine there is some enormous pile of circumstances which we can suddenly push into unexplained wealth orders. They will. It's although the burden of proof, the standard proof is less than in other circumstances. It is still a high bar if you're going to initiate expensive civil proceedings in the circumstances of unexplained wealth orders. What I would say is that, without going into detail, we have combed through all our existing casework and our intelligence information, and we have matters of interest that may in due course transmogrify into unexplained wealth orders. But there is no race between different agencies to get the first one. It's an extremely useful tool, and let's see how it goes. But I'm not going to bring it on until I get the right case.
So there.
Ghost Gouvet, reporter for acamsmoneylaundering.com. We're a news service covering financial crime compliance. I had a question about failure to prevent economic crime, the new offence we might see when the government finally responds to the call for evidence. I understand the government is quite divided about whether to bring in such an offence. Do you expect there will be a new, for example, failure to prevent money laundering offence? And do you see the SFO take a role in prosecuting such cases in the future?
Look, I'm a functionary. What the government thinks is up to the government. What I have said from as soon as I came in is that there is a perception in this country that corporate crime, and I mean by companies rather than individuals, is dealt with far more efficiently and effectively in the US than in this jurisdiction. The reason, as we have looked at many, many times, is the different legal test that applies. A company vicarious liability applies to the criminal liability of a US company, whereas in this country we have the more difficult task of, in order to convict a company of a criminal offence, of identifying the controlling mind, that is someone extremely senior in the company, and prove that he or she is complicit in the criminality. That is a big ask, and in practical terms very difficult. I have recommended that if it were thought that we needed a mechanism to more readily prosecute companies, the easy change to make would be to amend Section 7 of the Bribery Act, to which you've referred, from a company failing to prevent bribery by persons associated with it, to a company failing to prevent acts of economic crime by persons associated with it. Now, you speak about divided opinion on this. I am still stung by an event I attended that Alison organised at her august firm, and I was very chuffed before the debate when the audience were asked to press buttons and express their views for and against such an amendment to the law, and I was very, very chuffed because it said 89% in favour. So I thought, well, I've done this. We then had the debate for and against, and at the end the result was 89%, but it was against. So it was some
you haven't said who was speaking on the other side.
There were a number of
It might have been me.
Shocking interventions. But no, my point is, look, there are principled, perfectly decent opinions on both sides of this debate, and as I say, bring it on. I happen to be on to take a particular view, but some people get it wrong. Some people say, well, what's the point in prosecuting companies, and is this just going to lead to loads of company prosecutions? I don't think so, no, but it's a very useful tool to use in circumstances where, say, there has been a practice in an industry which is well known to companies within that industry, from which they have prosecuted and which amounts to criminal conduct. In those circumstances, I think it is right that a company should bear a criminal conviction for tolerating that kind of conduct.
Gentleman at the back.
Director, William Nicol-Gent. I'm a member, but I still am a chartered surveyor. 2 questions I may have missed. Can you give an approximation of how many cases that you get people to own up like good Boy Scouts and no more other than a bit of publicity, and how many, as a percentage, roughly go to prosecution? And
well, we've had 4 DPAs, and the rest is prosecution, or the investigation is closed.
Giving my age away slightly, when I was learning a bit of law some 50 years ago or so, people were still going around muttering that it was a great mistake to abolish the City of London special jury system that shortened trials considerably, where the jury was technically, shall we say, more savvy.
Yes, fraud trial juries, that's a very interesting subject. There are, again, very strong views on both sides of that divide. I was a barrister in private practice for 25 years, and I was wedded to the jury system. Since then, I think I have moved from that position slightly closer to sitting on the fence, in the sense that I'm really not quite sure. Because in at least, there are advantages and disadvantages on both sides of the debate, but with a judge-only trial, you get a reasoned judgment and reasons for the result. With a jury, of course, you just get guilty, not guilty, or we can't agree. And there's no explanation for that at all. Judges generally don't have pre-booked holidays in the middle of trials, but there are many judges who say, look, we don't want the responsibility of judging honesty or dishonesty. That's rightly the function of a jury. Some people say our cases are too complex. Well, I beg to differ. We spend most of our time trying to simplify complex facts into something that a jury can readily digest, rather than something which goes on and on. I don't like to have trials longer than 3 months. So there are problems on both sides of this debate, but as I say, I've moved towards sitting on the fence, which is rather unhelpful, but that's where I am.
Any other questions? Is there anyone who hasn't asked one before? Yes, the lady over there. There's just a microphone coming to.
Hi, my name is Victoria Tunikaite. I'm interpreter from Russian media into English, and I'm here to ask you one question, which is now mostly coming into England as well as European. What to do when prosecution is complicit in criminality?
When the prosecution is complicit in criminality, it's not a problem with which I'm familiar.
But this model is called symbiosis of prosecution and TV, and it's coming from Eastern Europe and Russia. It's a model of special structures implemented into prosecution, when they put prosecution being corrupt, and they are employed there to basically put a blind eye on crimes. and they are complicit in criminality, and this is how basically corruption gets away with everything.
I am very much aware that some countries struggle with issues of corruption. Indeed, I attended a conference on that very subject in Ukraine, and it's obvious that there is that problem. And I'm not saying even this country is free from corruption. I don't think we have a hugely clear idea or clear picture of domestic corruption. Some say there is corruption in our prisons. Some say the planning system is vulnerable to it. I don't know. I don't know what the evidence is, but I share your pain on corruption. But in this country, in terms of corruption within the prosecution institutions, within the judiciary, I would go to so far to say that is vanishingly small, if it exists at all. Even in England.
Gentleman there. Who's that? It's no gentleman.
Alex Carlisle, I'm her husband. David, I think most of us here recognise the great success of your tenure. Do you agree that it's causing a little bit of frustration in the private sector because the SFO is only able to prosecute a small proportion of fraud cases? Do you think that some of the work you do and the principles that you operate should become available to the private sector in controlled circumstances, and above all, that the private sector in private prosecutions should be able to recover proper costs, the costs of the prosecution in full when they are successful?
I'm aware, in a good way, that some forward-thinking firms wish to take advantage of their right to conduct private prosecutions. I think there are problems there. I think in terms of as soon as you start, as it were, and it's my word, not yours, privatizing this kind of activity, taking it away from a state agency, then I think there is always the danger that there can be conflicting motives. One can be, as it were, cash and profit driven, or you might be perceived to be cash or profit driven. Certainly my experience in relation to, say, confiscation, where on rare occasions back in, I once headed up the Revenue and Customs Prosecutions Office, as it then was, and we did use or get quotes from, at the very least, some people from the private sector, and the costs that we incurred from them were ruinous. So I personally do not favour that. I don't think I'd go further than saying you have rights, as you well know, to conduct private prosecutions, and if you're minded to do that and take those risks, then go ahead.
Tom?
Thank you. Tom Keating, I had a question about culture, because you've been in the office... Culture. You've been in the office over a period where the banking industry, I think of the City of London, the banking industry has been through considerable rigour. Yeah. And I suppose the question I have is, what sort of change have you seen in attitude, if any, from the city to the kinds of activity, libel fixing is obviously one of them, but the kinds of activity that in a way we all believe were going on in the city anyway? Has there been a change in attitude in the city towards this kind of thing? Have you managed to achieve a change through
2 points on that? One, I am an investigative prosecutor. I do not make moral judgments in any circumstances. Secondly, I would say that as a result of the Bribery Act, as a result of some prosecutions and as the result of well-publicised deferred prosecution agreements, I would say that compliance with the law has risen way up the agenda in the boardrooms of the city. I also think anti-bribery, anti-corruption has gone up the agenda. Much of that is due to the previous Prime Minister, David Cameron's, interest in it and his convening of a conference here in 2016. I think there is an awareness of corruption, a greater awareness of the damage it can do, particularly in the developing world, and also an awareness of the need for compliance within the city, and I think people are gradually coming around to realise that actually a compliant company can be a very successful company. It's a definite plus. It is not a negative factor on profitability.
Martin.
Just looking ahead to the years following you, where do you see the growth areas, so to speak, of fraud? What are the evolving challenges that you think your successor and successors indeed will face? And how do you think the prosecuting authorities can respond to any of those challenges?
Well, how do they respond? They respond thoughtfully and with conviction. But in terms of what's around the corner, as I said earlier, Martin, the problem is one really doesn't know what is around the corner. When I came in 2012, I was not expecting libel or anything like that. So one simply doesn't know. I imagine that along with compliance and anti-corruption, awareness of money laundering and the damage that that can do to this jurisdiction will also go up the agenda. We've talked about unexplained wealth orders. I think the big point here is that, assuming Brexit goes ahead, we will need to encourage incoming investment. Incoming investment requires two things. One, a rule of law jurisdiction, and two, a level playing field for all investors. And it's crucial, I think, that we maintain the level and determination behind our present enforcement of all those policies. And I imagine they will continue.
So.
Thank you. Excuse me. Hugo Rosemont, a member of the Institute here. Thank you for your remarks. It was with regards to your comment around seeing the banking sector as victim, that distinction, if I understood it correctly.
It's rather loosely used. That's where the bankers lost money.
To explore that, and if I may,
the account holders that lose money.
Indeed, and you know, reflecting on the fact that fraud, according to the Office for National Statistics, is now the most prevalent crime in the UK.
Yes.
And the conversation with the National Crime Agency, who perhaps are being more proactive about sort of seeking to address the industrial scale criminality now taking place against British businesses. Yeah. I'm wondering if this distinction, and would invite comment on the overall response that you see in the UK from law enforcement and prosecuting authorities as to taking that forward. I mean, if I may be so bold, we sort of can't end the debate at the fact that banks or other private sector companies don't want to report it because that might be embarrassing. Isn't it the reality that this is crime being conducted against business, and therefore where are the authorities to be able to support them, if I may be so bold?
Fraud is a huge subject, as you rightly identify. I have never believed in some kind of Stalinist model of fraud towers where, you know, some enormous skyscraper in Lambeth or somewhere, you have the serious fraud office on the top and you have DWP fraud on floor 34 and credit card fraud on floors 1 to 10. I don't believe in that sort of model. I don't think it works. We're a specialist agency. We do the topmost tier of that kind of work. Fine. Below that, below what we do, there is a complicated slew of fraud, much of it covered and very effectively by the Crown Prosecution Service, the City of London Police, and coordinated by the National Crime Agency increasingly, which can only be a good thing. Below that, of course, there is a huge tier of fraud. I suppose it's the third or even fourth tier of fraud, characterised, I suppose, by phishing with a PH and by credit card fraud. Now, much of that, frankly, there simply will never be the resources to dominate that on the part of the state. Much of that has to be dealt with and is rightly dealt with, I think, by education. That's something I think that the National Crime Agency will play a strong part in. People have got to take responsibility for their own credit cards and their own online identity and so forth, which, as I say, can only be a good thing. I think over the years, perhaps something one has noticed, I'm not sure when it started, but most police forces had a significant fraud squad attached to it. Numbers of police officers trained or fraud specialists have without question gone down over the last, 30, 40 years. Maybe that needs looking at again. So it's a balance, isn't it, of the right resource, the right devoted to it, and individual citizens taking responsibility.
So, just one lady right at the back. I think that's probably just got time for one more.
Thanks. Naomi Hurst from Global Witness. Today, the Tax Justice Network, hello, published its new Financial Secrecy Index. Over the last 6 years, how has financial secrecy offered by some of the world's largest and most secretive financial centres stymied your investigations?
Where there's a will, there's a way, and I can think of some jurisdictions, obviously, where one simply is not going to get evidence. But if it's the kind of jurisdiction you mean, such as British overseas territories and so forth, persistence pays off, I have found there. It'll never be a perfect picture globally until, some countries see that it might be in their benefit. Maybe it's not. Maybe it's not to their benefit, but. Our answer to problems like that is to try as hard as we can to get the evidence. I know that sounds simplistic, but it does actually work if you go and confront someone and say, we've given you a letter of request, we want it executed. So it's rather unsophisticated in that sense.
Is it a very quick question, sir? Okay, last one.
It's Andrew Watson from Transparency International. You won't be able to comment on individual cases, I appreciate, but I wonder, in your experience over your tenure, whether corruption within companies has, by and large, taken place by kind of rogue agents, rogue individuals or groups of people, or whether there has been a kind of the company's leadership has, or senior levels has within the company have kind of endorsed or encouraged or authorised some of that corrupt behaviour?
I think I've seen both, certainly, and one does notice, if I can turn it from a negative into a positive, you do notice, say, with Rolls-Royce, where I gave the example earlier, there was a very conscious decision to draw a line under the past and to put it right. I have seen that. So both occur, but in terms of my sort of knowledge of it outside casework, I usually look at the TI Perceptions Index and get my knowledge from there.
Well, I think that's all we've got time for, except I've got one last question, which is, I'm sure on behalf of everybody in this room, we want to know what you're going to do in April. You can tell us. We won't tell anyone. You can trust us.
As I hope I've made clear, the intention is to take some time off and then hawk myself around the bazaars of legal London and see if I can muster a flicker of interest.
Well, I think we all wish you well. Thank you very much, David.
Thank you.